To understand what just happened and why it matters so profoundly, you need to understand how criminal defense strategies actually work in high-stakes cases. Not in theory, not in television dramas, but in real courtrooms, with real prosecutors, real judges, and real consequences. When a defendant faces serious criminal exposure, the defense does not improvise. It does not rely on vibes or bravado. It identifies a single central pillar, the strongest asset available. That could be a witness, it could be a document, it could be a narrative supported by evidence. Whatever it is, everything else is built around it. Motions reference it. Public statements lean on it. Negotiations assume it. Jury strategy depends on it. The entire defense architecture rests on that foundation. And when that foundation doesn't just weaken, but reverses direction, when it becomes a weapon aimed directly at the defendant, the damage is not incremental. It is total. The building doesn't sag, it collapses. That is what multiple sources now say has happened to Donald Trump's legal defense. According to individuals with direct knowledge of the situation, Trump's defense team is dealing with what legal experts describe as a catastrophic strategic failure. The witness they built their entire case around, the person expected to neutralize criminal exposure, has flipped to the prosecution. Not partially, not conditionally, completely. Full cooperation, extensive testimony, thousands of documents, and most devastating of all, recorded conversations. This isn't just another legal setback. This isn't another headline in a long list of controversies. This is a structural collapse, and it changes everything. Why this is different from every other Trump legal crisis. There's a tendency, after years of non-stop political turmoil, to treat every new revelation as just another chapter in the same story. Another scandal, another outrage, another news cycle. But this is not that. This witness, whose identity remains protected, was not peripheral. They were not a disgruntled former employee. They were not operating at arm's length. They were present for critical meetings. They handled sensitive documents. They understood the internal mechanics of the operation. They were in the room where decisions were made. And according to sources inside the Manhattan District Attorney's Office, this individual has now agreed to testify under oath about everything they witnessed, every instruction, every approval, every transaction. The shift happened fast. As recently as January 7th, Trump's legal team was publicly confident. They told reporters the defense was strong, the strategy was solid. The prosecution, they insisted, had overreached. Then January 8th happened. That morning, prosecutors executed a surprise search warrant at the witness's residence. What investigators allegedly found there stunned even veteran white-collar prosecutors. Financial records documenting millions in undisclosed payments. Encrypted communications that, once decrypted, detailed the mechanics of the alleged scheme. And multiple audio recordings. Audio recordings of conversations with Donald Trump himself. By the end of the day, the witness was in custody for questioning. Within 24 hours, they had agreed to full cooperation in exchange for immunity. That speed tells you everything. What an immunity deal really means, and why it terrifies defense attorneys. Immunity agreements are not acts of generosity, they are calculated decisions. When prosecutors grant full immunity, they're saying this: what this person can give us is more valuable than punishing them. But these agreements come with a razor-sharp edge. If the witness lies about anything, if they omit material information, if they shade the truth, the immunity evaporates. They become prosecutable again for every underlying crime, plus perjury, which means the witness now has one overriding incentive: tell the complete truth, in full, no matter how damaging or embarrassing it may be. That's the position this witness is in. And that's the nightmare Trump's defense now faces. What the witness has already given. Prosecutors, according to sources familiar with the cooperation, over 40 hours of grand jury testimony so far. Approximately 3,000 documents. Detailed financial records and correspondence. Internal communications mapping decision-making. And 17 separate audio recordings. 17. Anyone who has worked in criminal law will tell you, audio recordings of a defendant discussing alleged crimes are extraordinarily rare and devastatingly powerful. You can't argue misremembering. You can't claim bias. You can't cross-examine a voice. If the recordings are authentic, they speak for themselves, and according to those briefed on their contents, Trump's voice is clearly audible. The discussions are explicit. In one recording, Trump allegedly emphasizes ensuring there is no paper trail connecting him directly to the activity. In another, he reportedly discusses specific dollar amounts and how to structure payments to avoid detection. This is not ambiguous language. This is not coded euphemism open to interpretation. If the descriptions are accurate, this is the kind of evidence prosecutors dream about and defense attorneys fear most. Inside the legal meltdown. Inside Trump's legal operation, sources describe a state of chaos bordering on collapse. Emergency meetings are happening constantly. Lawyers are arguing openly over who trusted this witness, who built the strategy, who misjudged loyalty. At least 2 senior attorneys are reportedly preparing to withdraw entirely. That matters. Criminal defense attorneys do not walk away lightly, especially from high-profile clients. When they do, it's usually because they believe the case has become ethically or strategically untenable. One source described the mood as oscillating between rage and disbelief. Not just fear of losing, but fear of what the witness knows that hasn't surfaced yet. That fear is well-founded. The defense strategy that just imploded. For more than a year, Trump's defense rested on a single narrative. Any illegal actions were taken independently. Trump was unaware. He did not direct or approve the conduct. The witness was supposed to take the stand and confirm exactly that. This is a classic defense tactic in cases involving powerful figures. Isolate responsibility, create distance, generate reasonable doubt. Trump's team filed motions based on this assumption. They made public statements relying on it. They rejected plea negotiations because they believed this witness would protect the core. Now that same witness is prepared to testify to the exact opposite. That Trump personally directed the actions, reviewed the documents, approved the payments. The defense narrative doesn't just fail, it becomes the prosecution's case. And it gets worse. The cascade effect. According to prosecutors, the witness is not only confirming existing charges, they are revealing new criminal activity investigators were previously unaware of. Additional financial crimes, possible obstruction of justice, potential election law violations. One prosecutor described it as Christmas morning. And once a major insider flips, something else happens. A cooperation cascade. Other potential witnesses begin to reconsider. Silence becomes riskier than cooperation. Loyalty looks less rewarding than immunity. Sources say at least 2 additional figures are now in active talks with prosecutors. An investigation that once appeared contained is now accelerating. Fast. The financial evidence. The paper trail that ends arguments. White-collar cases often hinge on documentation. According to sources, what prosecutors now have is unprecedented in scope. Bank records, wire transfers, shell companies, hidden accounts. But more importantly, they have context. They understand the code words, the structure, the intent. One forensic accountant described it as the most complete financial map they'd ever seen. And then there's the most explosive revelation of all, a second set of books. Not accounting differences, not aggressive interpretation. Parallel records allegedly showing the real numbers. That's intent. You don't accidentally maintain 2 financial realities. The recording that changes everything. Among the recordings, sources describe one in particular that has stunned legal observers. In it, Trump allegedly discusses what would happen if the scheme were exposed, suggesting the witness take the fall, and referencing the possibility of a pardon. If accurate, this implies knowledge the activity was illegal, anticipation of discovery, planning for obstruction, contemplated abuse of pardon power. That's not inference, that's articulation. Why legal experts say this is a nightmare scenario. Criminal defense attorney Sarah Chen called it the worst possible scenario. When a defense witness flips, she explained, they don't just remove your evidence, they hand your entire playbook to the prosecution. Former federal prosecutor Michael Torres added that flips of this magnitude are exceedingly rare, and the damage isn't just evidentiary, it's psychological. The defense must rebuild from scratch while the prosecution knows every move they originally planned. It's like playing chess when your opponent already knows your endgame. Security measures that speak volumes. The witness has been relocated. They're under federal protection. Communications are tightly controlled. These are not standard measures for financial crimes. Prosecutors have received credible threats. The FBI is involved. That tells you the stakes are real. Political shockwaves. Republican lawmakers who once defended Trump loudly are now silent. Messaging is collapsing. Fundraising narratives are strained. Strategists admit they're in crisis mode. The witch hunt narrative doesn't work when the evidence comes from inside the House. Timeline pressure and expanding exposure. With cooperation secured, prosecutors want speed. Trial could begin far earlier than anticipated. Meanwhile, federal agencies, from the IRS to the DOJ, are requesting access to the witness. This could expand far beyond New York. Obstruction evidence, the prosecutor's favorite weapon. Texts discussing evidence destruction, coordinated testimony, witness intimidation. These aren't just crimes, they show consciousness of guilt. Innocent people don't cover up nothing. The personal dimension. The witness has knowledge involving Trump family members. Legal teams are scrambling. Trump is reportedly furious, and his public attacks on the witness may themselves become evidence. Where this goes next. Prosecutors are preparing a comprehensive case presentation. The defense is running out of options. Behind the scenes, conversations once unthinkable are happening. This isn't about politics anymore. It's about evidence. We don't yet know every detail. We don't know how jurors will decide. But we do know this. A defense that once stood has collapsed from within. And when your most trusted insider becomes the prosecution's most powerful witness, the legal calculus changes forever. This story is still unfolding, and we'll be watching every step.